Okay, well, there are still people joining in, which means that I'm going to have to, while I share the screen, I'm going to have to manage admitting new people. But in the meantime, I want to thank all of you for your interest in this course. I received a lot more interest than I was expecting at the international level. I'm very, very happy about that and very honored that you would want to take time off to talk about this topic with me specifically. Now I'm going to start projecting this, and we're first going to go through some preliminary issues. So here we go. Okay, so hopefully you can now see the presentation. So as you know, this course is going to be taking place from the days 11 to 15 of May 2020. And this is the schedule as we move forward. Could somebody please confirm that you see the presentation without any obstruction, because I have to have other windows open here at the same time?
Me too.
Yeah, okay, good, thank you. All right, so this is the schedule for the days of 11 of May, 12 May. You've already received this, hopefully, so it won't be surprising. We will be going through all of these topics that have a different depth. Some of them we're going to take quite some time. Others we can go through them relatively quickly. To begin with some workshop rules of conduct, we're all very used to working on Zoom by now, but just let's go over this quickly. I see that I can tell by everybody's behavior already that these rules are absolutely unnecessary, but in any case, please do keep your camera on if your internet connection allows, and keep your microphone off unless you're intervening. I will always be trying to project these slides, and hopefully you will be able to see me and the slides and other people intervening in parallel. So there are little functions you can use for that. Then I really look forward to having your participation. So feel free to participate at any time. And in order to participate, what I would ask is that you use the chat function. So first write to me on the chat. You can do it privately, just to me, or you can do it publicly. This is also an interesting way if you want to do comments throughout the class. Why not? You know, like on a YouTube channel. And this gives me your feedback as we go along, and it might be very interesting for me. The other thing is, if there are any technical difficulties, please advise me at once so that I can address them. Now, what else? This is specifically for University of Lisbon Law School students who are taking this course for credit. If you are taking this course for credit, you will be required to submit a written paper, and in order to be approved, you'll have to get a score of 10 out of 20 at least on the paper. The paper will have to be on a subject of your choosing within the subject matter of the course, but please do double check the topic with me before you get started. So send me an email with your proposed topic to my law school address. The paper is supposed to have between 7 and 15 pages. I mean, I just put there an example of the kind of font and spacing I thought of when I came up with these limits. And do send it by email to my address by the 31st of May. I really should have checked this date with the Erasmus office, but I think it's okay if I give your evaluations a little after that date. There is absolutely no tolerance for plagiarism, so please be very careful with that. Don't copy paste anything without indicating where you've taken that from. Just to give you a little incentive, any papers that I deem to be outstanding, I will invite the students who submitted them to possibly do some revisions and then submit them for publication in the Portuguese Journal of Competition and Regulation, which is a peer-reviewed paper, so publication is not guaranteed, But if I am suggesting it, it's because I believe it has the quality to pass that evaluation. Okay, now let's go back to everyone. So who is this course for? Especially considering the interest that I've received from many countries and many people with many different backgrounds, I've decided to try to adapt the course so that it would be, of course, for the non-initiated, but also include several advanced discussions for people who are already connoisseurs. And in that sense, I have to say, I probably ended up the scale probably tipped a little bit more to the side of the advanced discussions. I hope that people who are being initiated will still not get lost in the discussions and will find this kind of more advanced discussion interesting. Topics 1 and 2 will be mostly for the introductory level, and then all the other topics, if all goes well, will have something relevant also for the advanced level. And indeed, some of the people who told me that they were intending to look at this course, to attend this course, are practicing lawyers, professors of competition law. So we have to find something for everyone in the middle of this. And I would like to start a bit by justifying the title that I gave to this lecture. Why is it that the law and case law on private enforcement of EU competition law, why is it that this might give us a preview of the future of civil litigation in the EU? Of course, we will be discussing this throughout the several days, but I would just like to begin by saying that there are 5 main reasons for this. One is that we find in the damages directive very advanced solutions, which are incredibly innovative at the EU level, surely, but also at the national level. Solutions of civil law and civil procedural law that are unrivaled, or at least they are inspired by several solutions that are found in some member states, and they take a little bit of the best of everybody to come up with a highly effective system, in my opinion. And so we might be seeing this directive inspire other directives in the future and other legislation. A crucial role is being played by the case law. The case law is taking European Union law to levels that most people, the vast majority of jurists all over Europe, still don't even realize because they're not well informed about this case law. And it will have implications that will far outreach, already has had implications and will continue to have implications that far outreach the scope of competition law. And much of this is connected to the fact that this case law is based on general principles, and especially the principle of effectiveness. And if you understand why the court has arrived at a certain conclusion and a certain solution in relation to these matters of competition law, it's very easy to extend that same conclusion, those same principles require the same solution in other areas of EU law. And finally, I think that competition law and this revolution that we're seeing in the private enforcement of competition law will lead both the European Union and national legislators to want to extend these solutions to other fields sooner or later. And we've witnessed this already in some areas of EU law. So it is my contention that some of these solutions that we will be looking at throughout this course, we will, in the years to come, find them also in other areas of the law, either through general rules or through special rules, which will be created for those other areas of the law, either at EU level or at national level. Let's begin. As I said, the first chapter has to be introductory. There are people here who have never had competition law. And there are some people here who might know something about competition law, but they haven't had, they're not even from Europe, so they don't know necessarily about EU law. To be fair, I'm probably, inevitably, I'm going to have to assume that certain knowledges of EU law are already held by the people watching, because otherwise it gets too difficult. But I'll try to explain things in a way that even for non-Europeans will make it possible to follow. So, competition law. Competition law is a branch of the law that is fundamentally aimed at preventing distortions of competition. Distortions of competition that can be created by companies, by private persons, private or public persons, any person having an economic activity, or by states themselves, acting not as an economic activity, but acting under powers of authority, for example, or pursuing missions that are associated to public goals, associated, for example, to solidarity. So competition law is not only aimed at the behavior of undertakings, it is also aimed at the behavior of states, broadly speaking. There is, in the European Union, EU and national competition law. So each member state has its law, the European Union has its law, and well, we're going to explain this in a little bit of more detail in the next slides, but they're applicable in parallel. And as is a characteristic of European Union law, EU law has primacy over national law. And so that also is the case in competition law. It's the same thing as the relation between federal and state law if you're coming from a federated state. EU and member state competition law, however, are virtually identical. They have been largely harmonized. And so typically, when EU lawyers discuss competition law solutions for a given practice, they don't really distinguish whether or not they're talking about EU law or national law, because almost always the solution is the same. That being said, there are very important reasons, and recent cases have shown that to be crucial. There are very important reasons why we need to discuss when EU competition law is applicable. Sometimes there is the tendency to say, well, what does it matter? Let's just apply national law. It doesn't matter if we apply EU law. That's not the case. The main reason for that is that if you don't apply EU competition law, you don't have access to the protection of EU law. And everything that we're going to be studying throughout this course shows how important that protection is, how EU law guarantees you rights, substantive and procedural rights, that you would not have had access to if you were only litigating with national law. So it really is a simplifying and short-sighted view to say it doesn't matter if we apply national law or EU law. And I'll get back to this a little bit later. Competition law is divided into three main fields. We have antitrust, also called restrictive practices. We have merger control, and we have state aid. So let's look at these each in turn. Antitrust. Antitrust is made up of Article 101 of the treaty, and of course, the corresponding national rules. So in Portugal, it would be Articles 9 and 10 of the Portuguese Competition Act. This concerns collective practices, practices between more than one undertaking. Undertaking understood as an economic unit, meaning a group of companies, the same corporate group. Collective practices are divided up into three types: agreements, concerted practices, and decisions of associations of undertakings. Then we have unilateral practices, and unilateral practices are divided up into two types. At the EU level, we only have one type. So we have Article 102, and every member state has its corresponding provision. Article 102 prohibits abuse of a dominant position. A company with a dominant position, and really there can only be one dominant position in any market. There is a figure of a collective dominance, but it's marginal. The requirements are extremely high, and there are very, very few examples of ever a position of collective dominance being identified. So abuse of dominance position is the unilateral practice which is forbidden at the EU level. For both collective practices and abuse of dominant position, you have regulation EC 1/2003 and many other documents of secondary EU law and soft law. Now, there is another unilateral practice which is forbidden by the competition law of some member states, and that's abuse of economic dependence. Portugal has it, France has it, Germany in somewhat of a different disguise has it, and some are creating it now. Poland has it, Bulgaria, I think, just created it, if I'm not mistaken. So this was thought to be a bit of a figure of the past, but it's seen a resurgence in recent times. The idea here is that you do not have a dominant position over the market, an absolute dominant position, but you have a relative dominant position over someone, over a specific undertaking. And well, economists are not big fans of this because it's not easy to identify a situation of relative dominance if there is no absolute dominance. So typically, competition authorities don't really go after these cases because they have a high burden of proof and it's just hard to meet the requisites. But in private enforcement, yeah, in private enforcement, it's been used, and courts, some courts are not as demanding when they meet the burden of proof. They're persuaded by what they perceive to be situations of injustice. So you do find examples of abusive economic dependence being applied in private enforcement. Now, fundamental issue that has to do with that discussion about when do we apply EU law or when do we apply national law. So national law is applied whenever there are effects within that country. It's an effects theory. So it doesn't matter where the practice occurred, it matters where it was felt, where its impact was felt. And the same is true for EU law, but with a little change, which is that EU law is only applicable if the effects are cross-border, meaning if there are effects on trade between member states. Typically, this has led many courts and even competition authorities, in the case of the courts, because of misperception of the case law usually. In the case of authorities, it has usually more to do with simplifying their procedures. There is often the tendency to say, well, this is a practice that only happened in Portugal, only Portuguese law will be applicable to it. And that is just absolutely wrong. The threshold for effect on trade between member states is very low. It has been clarified abundantly in the case law, and there is even a presumption in the case law that if a practice extends to the totality of a market, of a national market, so if a given restrictive practice encompasses the entire national territory of a country, you should presume that there is an effect on trade between member states. So it's exact opposite, in fact. Courts have the tendency to say, oh, it's only in Portugal, it's the Portuguese national market, we're going to apply Portuguese law. It should be the other way around. It should be, oh, it's the Portuguese national market, therefore we have to apply EU law as well. And this is complicated because we've seen a lot of cases. We're going to talk about one of the famous cases, Cogeco, which is the litigation at the national level after the European Court of Justice decision is very tied to this issue of, okay, we asked the court a question, but now the national court says that EU law isn't even applicable. Even though it asked the court a question about EU law, now it's saying it's not even applicable. And that drastically changes the outcome. So these questions of when EU law is applicable will be decisive very, very often. Okay, so how are antitrust rules enforced? You have public enforcement on the one hand, and you have private enforcement. Now, public enforcement is done by the European Commission, judicial review by, of course, the European Court, but it is also done by the member states' national competition authorities, and then those decisions are reviewed by national courts. At the national level, you have something else that you obviously don't have at the EU level, which is there can be questions posed to the European Court of Justice in a principle of cooperation. Please clarify a certain rule. And there can be appeals after the appeals in the national courts have been exhausted. There can be appeals to the European Court of Human Rights, which of course you cannot do at the EU level because the EU has not joined this convention yet. Let's move on to merger control. Merger control is, of course, the control of concentrations. It is foreseen not in the treaty, but in that regulation, 139/2004. And every competition act or competition law of the member states has its own merger control rules. The idea here is that before a concentration takes place, it has to be approved by public authorities. These are mergers, they're acquisitions, and they're full function joint ventures. Now, how do you determine if a certain concentration has to be approved? You have to meet the thresholds, and the thresholds are almost always based on turnover alone, meaning if the companies participating in this concentration have a lot of basically their aggregate turnover is very big. This means that you need to notify it either to the national competition authority or to the European. So each law has its own turnover threshold. Some laws, like Portugal and Spain, they're the exception. They also have not just the turnover, but also have the market share threshold. Somebody is asking if we're going to talk about merger control, gun jumping, and failing firm. No, that is not within the scope of this course. Unfortunately, we don't have time to go over those. Merger control, therefore, is enforced by the European Commission when the EU threshold is met, and there it becomes a one-stop shop. So if the EU threshold is met, you only notify to the European Commission, and you don't have to notify to any European country, and they decide. And of course, judicial review by the European courts. When the EU threshold is not met, you have to go country by country deciding to see which of the thresholds are met, and then you have to notify it to the competition authorities where the threshold is met, and then you can appeal again to the national courts with possible referral to the European Court and a possible appeal to the European Court of Human Rights. Let's move on to state aid. State aid is foreseen in Articles 107 to 109 of the treaty, and of course in many documents of secondary EU law. It is a branch of competition law which is specific to EU law, and although there are now some other countries in the world that have it, the examples that I am aware of, it was created because of their neighbors to the European Union, and it was created by requirements of the European Union that they do so in the context of preparing to maybe join the EU in the future. The idea for state aid rules were basically introduced as an exchange for the creation of the internal market. I mean, Germany would say to France and vice versa, look, we will allow you to freely ship your products to Germany with no restrictions and with no tariffs, etc. But we have to be sure that you're not going to distort the competition by giving incentives to your companies and lowering their costs. And giving them a competitive advantage over ours. Plus, everybody's interested in preventing a Delaware effect, which means a race to the bottom. So state aid is there fundamentally to prevent distortions of competition by public authorities, and it prohibits them from giving selective advantages to undertakings who are competing in the EU internal market. There are exceptions, of course, but these exceptions they have to be authorized by the European Commission. So you can come up with a justification. Well, I am giving a selective advantage, but I need I'm doing it for a company that's going to set up in a region that is very poor. There is a good public policy reason to give this aid. And then the European Commission has to say, okay, I agree, and it is proportional. Okay, so there is a supranational political legal control of the proportionality and the adequacy of these measures. So enforcement here at the public level is done exclusively by the European Commission. National authorities have no role to play, and judicial review is done by the European courts. Please note that it's not like you always have to notify state aid and be authorized. There are a lot of block exemption regulations that set up safe harbors. If it meets these criteria, it's automatically approved. It's not that it's automatically approved, it's not even forbidden. And there are also general authorizations of state aid regimes. The state asks for permission not for one aid, but for a category of aids, a regime of aids. And then once that regime is approved, it just grants aid within that regime, within the limits of that regime. And sometimes they might say that it is within a block exemption or within a regime, and it is not. So there's that kind of problem. Okay, I am about to move on to the next chapter, but this would be a good time to stop if anybody has any questions to ask about competition law itself. I've been carefully monitoring the time that I'm using, and I think I'm still okay. Um, does anybody have any questions? You can express yourself in the chat or no. Okay. All right, well, let's move on to private enforcement. Oh, okay, we have a question from Jose Moreno. Go on. Turn on your mic, please.
Wait, can you hear me? Sorry.
Yeah.
Yeah, I have just one question. You mentioned that there can be questions asked to the CGU for clarification of certain EU rules, but what if a Supreme Court rejects to submit those questions to appreciation? How can we react to that?
I think I sense in your question a reaction to the German Constitutional Court decision of a few days ago. Yeah, it's a problem. There is, this is a problem that occurs even in federations. If a Supreme Court refuses to submit questions that it was required to submit by EU law, this has already happened. In fact, the first case where this was discussed was from the Portuguese Supreme Court. It was a behavior of the Portuguese Supreme Court. And the consequence, as clarified by the court, is that there was an infringement of EU law. There can technically be infringement proceedings if a member state or the Commission starts them. But the more interesting perspective from a private enforcement point of view is that you can then sue the state of the court in question for damages because they infringed EU law and in so doing caused you damage. So that's the issue that was clarified back in 2014, if memory doesn't fail me, because of that exact behavior of the Portuguese Supreme Court. But then that doesn't really solve the issue because courts can, it'll go up to the Portuguese Supreme Court again, ultimately. And if, as we've seen in the German Constitutional Court decision now, ultimately, if a Supreme Court or a Constitutional Court doesn't want to comply with EU law, there's really nothing to prevent it from doing so because there is no appeal. So the only thing that we can do is start an infringement proceeding, and that is mostly up to the European Commission because no member state is going to do that against another member state. Let's see if the European Commission does that now in reaction to the German Constitutional Court. Very interesting question. I would like to now then move on to private enforcement itself. And let's see what this is all about. But of course, to understand what private enforcement is about, we first need to understand what public enforcement is about. And this slide is more important than you might think because it's going to tie into a lot of the discussions that we're going to have in the next days. And you need to understand these characteristics of public enforcement in order to then be able to understand the next discussion. So the public enforcement, what we describe as public enforcement, is the application of competition law by the competition authorities. Usually these are administrative authorities, the European Commission, for example, most national competition authorities. There are some states, for example, Austria, where the decision might be prepared by an administrative authority, but it has to be taken by a court. But those are the exceptions. It's possible, and it's foreseen in Regulation 1/2003 as one of the possibilities. So you have the public enforcement is the decision of the competition authority, and of course the judicial review of that decision. In some countries, very, very exceptional, I think Ireland is one such example. In some countries, you also have the possibility of criminal proceedings in the USA, for example, as well. Criminal proceedings for antitrust infringements. And there have been long discussions whether or not we should have that. It's not entirely clear that it's more dissuasive because, especially in Ireland, has been a good example of this. The track record for success in antitrust criminal proceedings is very poor. And so it's, the dissuasive effect is not great. Somebody is asking if you will be receiving the PowerPoint presentation. Yes, I will be providing the PowerPoint presentation to students at the end of the course, but I only have the emails of the University of Lisbon Law School students. So to those I can send, to others we have to come up with a solution if you want to get access to the PowerPoint. Now, what do these decisions entail? What do they lead to, these competition authority and court decisions, judicial review decisions? Obviously, they can close the case because there is no evidence for the infringement. or because they're trying to prioritize. They say, well, there might be an infringement here, but we just have too much work. We have more important cases. We're not going to pursue this case at this time. But there can also be declarations, like a positive declaration, a negative declaration of an infringement, meaning that the behavior is lawful. This is foreseen at EU level. It is possible in the laws of some member states, but there is a very important caveat there, which is that it can only be done when only national law has been infringed. National competition authorities cannot do negative declarations for EU law. It's forbidden by the case law. As far as I know, this has only been done once. The European Commission has only once done a negative decision, a negative declaration, and that was now because of COVID, where they came up with a decision saying that certain practices of cooperation would be lawful within certain restrictions, because they felt it was important to clarify this for the legal community. Then, some cases are closed with commitment decisions. This is important. A commitment decision is basically where the competition authority first issues a statement of objection saying, we think you broke the law. And the company comes back and saying, well, if we promise to do this and that, will you please not declare the infringement? And the competition says, okay. So it doesn't declare the infringement, but it renders those commitments binding upon the company. Typically, this means that the unlawful behavior is solved for the future, but there is no solution whatsoever for the past, and there is no declaration of infringement for the past, technically speaking. But we're going to see that the case law has introduced a bit of a nuance, very important nuance there for private enforcement. Commitment decisions are becoming they used to not be so used, and now they're becoming more and more used by several competition authorities. And then, of course, you can have positive decisions, decisions that declare the infringement, and they impose fines, and maybe they impose other sanctions. You can have structural sanctions, require a company to break up. You can have per diem fines to make sure that the company complies with whatever behavior is being required of it. You can have that company excluded from public tenders for a certain amount of period, et cetera, et cetera. Okay, depends on the different laws of different countries. So, yes, I will be talking about I'm answering questions from the chat. I will be talking about commitment decisions, implications for private enforcement when we reach that chapter. It's in one of the topics. Now, these declarations of infringements, sometimes they're taken in the context of leniency programs. That means that somebody came forward and said, oh, I did this, please don't fine me, and I will do my very best to help you prove that we did this. And the first applicant gets immunity, and if successful, and the second and third applicants usually also get reductions, usually 50% and then 30% reduction of the fines. Leniency has become a crucial tool for competition authorities to identify cartels, because they're secret and they're very hard to detect, especially because they've gotten very sophisticated. So there is this perception that without leniency policies working, that cartels would not be discovered, or at least they would seldom be discovered. And this is a big concern because of the interplay with private enforcement. Competition authorities for quite a while believed that if private enforcement became very successful, they would stop having leniency applications. It's still too early to see the impact of successful private enforcement on leniency applications. We'll have to look back in a few years and see if that is true. But I would venture a guess that the risk of having to pay the fine is still going to be sufficiently dissuasive, given the instability in cartels, for companies to go forward with leniency applications. Furthermore, competition authorities are doing their very best to invest in alternative ways of detecting cartels, not just with inspections, but also with sophisticated econometric ways of detecting cartel behavior on the market based on data. This is especially being done for public tender markets, which is very interesting. And then there is something else, which is another way that these infringements are declared. Sometimes competition authorities arrive at a settlement. The undertaking promises not to challenge the decision. Sometimes that involves confessing the infringement. And in exchange, it gets a reduction of the fine, let's say maybe 10%. And settlements have become more and more frequent because, in my opinion, because of private enforcement. Companies are very afraid of the compensations that they will have to pay under private enforcement because there will be usually potentially much higher than the sanctions, and therefore these companies go to the authorities and they say, look, I won't challenge your decision, but please reduce the fine, give me a little reduction. But that's not the most important thing that they're after. The most important thing that they're after, if their concern is private enforcement, is let's negotiate the content of the decision. Settlement decisions are very, very short and very, very imprecise about what happened. And so people who are injured by the practice don't really have much to hold on to if they want to do a claim for compensation. And that's the whole point. It's to make it harder for people to go to court and obtain compensation. Now, there's a lot more to it, but I'm just giving a slight introduction to why settlements have become more used and why they're so problematic for private enforcement. And we've had a great example of this recently in Portugal, where in the same cartel, two companies didn't settle. They got a decision with 200 and something pages, and three companies settled. They got decisions with 50 pages. Completely different descriptions of what happened, and it has an impact, of course, on private enforcement. Now, the EC, just a final detail, the EC imposes sanctions only on undertakings. Some competition authorities will also impose sanctions on managers, on natural persons. But it is not clear that that this probably doesn't have a direct impact on private enforcement. I don't think I'm going to have time during this course to discuss the possible liability of managers, but do keep in mind that that is one possibility that is discussed at a very high level, whether or not the compensation claims can be also filed against the members of the board, for example, the CEO, etc., of the company who did the infringement. Okay, so what is private enforcement? In private enforcement is basically everything else. Sorry, I'm just checking if I am within the time restraints. I think so. So private enforcement is every situation that is not public enforcement. What does that mean? It's every situation in which a dispute is settled through a dispute resolution mechanism, which can be a lot of things. It can be a court, judicial court. It can be arbitration. It can be theoretically mediation. And in this, a public or a private person will invoke EU and or national competition law in support of their rights, in support of their interests, or in support of collective interests, or diffuse interests, the interest of protecting competition on the market. This is important. In Portugal, we have this is very important because we have actio popularis, popular actions, precisely to defend collective interests. It can also include the use of legal procedures to prepare or to follow up on such actions. So to request access to documents, for example, or to execute a judgment. So it's all of this, except when it is directly relating to or pursuing the application of competition rules by a competition authority. And one of the things that is often overlooked, too often overlooked, and in fact, the damages directive completely overlooks this aspect, is that private enforcement is not just for antitrust. Private enforcement is also for state aid, and it's also for merger control. Now, it is true that the vast majority of private enforcement that we know of is for antitrust, but we do have in several member states, including in Portugal, many examples of state aid private enforcement. There, in my cases, in my studies in Portugal, I've identified at least 9 examples of actions of private enforcement of state aid. But there are many, many others. And this is one of the areas that has been overlooked and that needs more attention, because private enforcement will contribute to public policy goals. Why isn't the Commission fostering that private companies go onto the market and monitor whether state aid rules are being complied with? This will be helpful. But also merger control rules. You can have actions for damages based on unlawful mergers that were not authorized, for example. And this is absolutely unheard of, as much as I know, in the EU. And we've only recently had the first case of this type in the USA. So this is the most neglected, almost virginal area of private enforcement of competition law. Of course, from here on in, almost everything that we will discuss will have to do with antitrust, but I will mention some state aid cases. Now, what types of claims, what types of actions might you see within private enforcement? And this is, I purposely put this slide here because I want people to stop thinking about private enforcement as actions for damages. Remember, the damages directive, that's what it's called. The directive on actions for damages, which is ridiculous. It should be the private enforcement directive. All of these bullet points, damages is one of them. One of them. The damages covered by the directive is only one of these bullet points, and yet private enforcement is all of this. So it can be decisions, and by the way, they are set in the order of frequency, at least up to the damages directive. So it's not even, damages actions are not even the most frequent. The most frequent are actions where there are claims that a certain contract or a contractual provision is null and void because it infringes competition law. And typically that is used as a shield in litigation. So somebody says, I don't have to pay what the contract says I have to pay because that clause is invalid, or the contract is invalid. That would be one example. This is the vast majority. If we look back to as far as we can, this is the vast majority of actions that we have at the national level. But that is changing now. Then we have damages actions. Damages actions can be follow-on, standalone, or mixed. I will explain a little better what that means. They can be claims by applicants, but they can also be counterclaims by defendants. Then you have actions that seek disclosure. They seek access to evidence. And you need evidence, you need documents, not just to prove what you already know, but also to assess whether you have a right to damages. And this is very important, also very overlooked in the directive. The directive only talks about access to evidence after you file the damages claim, but that doesn't solve your problem because you need to meet your burden of, sorry, I don't know how to say this in English, of allegation. So there's the burden of proof, but then there is also the burden of alleging all the facts that you need to allege. And you cannot add new facts after you file the thing. Well, I mean, it varies from state to state and depending on the interpretation of the judges. But typically, you need to have access to evidence very often, even to understand if you have a right to damages, if there has been an infringement, and if that infringement has affected you. So disclosure is very important, not just post-filing, but also pre-filing. And you also have the possibility of ordering provisional measures to preserve evidence. Some national laws already foresee this specifically. I would argue that the principle of effectiveness requires everybody to foresee this, even if they don't. Then there are injunctions to cease an infringement. Of course, don't forget, these can be put together in the same action. You can have one action for injunction plus damages if the behavior is still ongoing. And it can also be provisional measures of injunctions. And then you have annulments of, now we come into the ones that are less thought of. Annulments of public tender procedures, where infringements of competition law are invoked, usually before administrative courts. You have decisions concerning state aid, to suspend a decision, a public decision, or to annul that decision, or to recoup, order the recoupment of unlawful state aid, or some of these put together. You have incidental arguments in bankruptcy proceedings. You have negative declaratory actions, which is gained the name of the infamous Italian torpedo, which is when you file an action in a court which you know is slow, saying, I don't owe that other person anything. And you file the action before the person files a positive action against you. And then you say, lease pendens. We already have an action in Italy. Yes, it's going to take 20 years to be decided, but it's the same issue. It's being discussed in Italy, so now you can't discuss it in Portugal. Yeah? So that's one of the interesting developments that we've seen in competition law, but it's not just from competition law. Then you have damages claims against the member state due to unlawful state aid, and this is extremely rare. I think I've heard of one case where this has happened, but it should happen a lot more often. And then you have incidental argument in labor disputes and debt enforcement proceedings relating to unpaid antitrust damages. So there's a whole range of things that you can be talking about. But of course, we'll end up talking almost exclusively about damages because that's where most of the doctrine and the legislators have been focusing their attention. Where are private enforcement cases litigated? I've already said, so of course they can be litigated in judicial courts, but don't think just of civil courts, generalist courts. You can have specialized courts or chambers, typically like a competition court in some countries, like the UK, like Portugal also. You can have courts with other specializations that you wouldn't think that they would have to discuss competition law, and they do. Commercial courts, administrative, bankruptcy courts, tax courts. They will often end up having to have these discussions, and the poor judges, they thought that they could specialize in their own field, and all of a sudden they have to study competition law, which is not at all easy to do if you're a busy judge and you have very little time to study. And you also have arbitration. Now, arbitration, there are probably a lot of cases we just don't know, because the only cases which we do know are the ones that are appealed. For those of you interested in arbitration, competition law is considered rules of ordre public, and so you can appeal. It's one of the exceptions. You can appeal arbitral awards on the grounds that they infringed competition law. So you do have more appeals than you would have in other areas, but still, I would assume that we see only a small percentage of the cases of arbitration that are out there. But of course, arbitration will be a tool used primarily, at least at the EU level. In the US, you have a lot of arbitration clauses for consumer contracts, and that brings up a lot of problems. But in the EU, arbitration will be typically used in disputes between large companies, or at least medium and large companies. No example whatsoever is known of mediation of competition law disputes. It's possible, we just don't know about it. Okay, as I will try to do always, before I move on to the next chapter, are there questions about this issue? About the things that we've discussed? Oh, there is, I'm sorry, I have the one window on top of another, and I haven't seen some questions that are already here. So somebody says, being that the scope of damages directive does not include state aid, is it inapplicable in that area? That's right. It does not, the damages directive does not require member states to make their laws applicable to infringement of state aid. Each member state can decide to do that. And this was very, very profoundly discussed in Portugal when we were transposing the directive, but almost no state did it. I think no state did it. I'm not sure. Memory fails me. But the directive itself does not apply. It should. So that's one of the issues to consider in the revision of the directive. Somebody said, somebody tried to help demonstrate standing. Maybe they were talking about the burden of allegation, and I think that's a different issue. And which type of action can potentially be requested for a allegedly unfair merger review? No, it's not that it's unfair. So it's not that the merger review was unfair. I'm saying if the merger was not notified is when I imagine that there would be private enforcement actions. Of course, third parties can sometimes challenge decisions of competition authorities about a merger, but then you'd be talking about public enforcement. You wouldn't be talking about private enforcement. It can then lead to private enforcement, but that action itself would not be private enforcement. If there are no other questions, I will then move on to history and status quo of private enforcement of competition law in the EU. Okay, so what's important to note is that we could have had private enforcement since 1974, because private enforcement, since the BRT v. Sabam case, because private enforcement is based on a very simple idea: the direct horizontal effect of Articles 101 and 102. Articles 101 and 102 impose obligations directly on undertakings, and so they can be invoked by other undertakings who have derived rights, and those rights, that's what direct effect is all about. Those rights are assigned to them directly, or they derive directly from the EU legal order. And all of that was clear by 1974. I mean, clear to some in any case. And this is an interesting part of, an interesting idea that we're going to see throughout the history of private enforcement. There are some things that when we look back, we think, well, that was obvious back then. And yet some clarification based on general principles. And yet the reality is that it took many, many years to understand the full consequences of clarifications done by the court. And to be fair, the court itself, we're going to see that several times, the court itself was not entirely clear on the consequences of the things that it was saying. We have, well, at least some of the members of the court, because as you know, the judgments are written collectively, and so some paragraphs might suggest one thing, which was not necessarily the opinion of all the judges. But it's interesting to see that there are certain principles now that we think, oh, that's and consequences, well, that's what's obvious. But even judgments of the court hesitate about that and go, you know, you look back at those judgments and you say, well, the way we understand the law, yeah, we can reconcile with that, but there are some difficulties of reconciling with what the court was saying at the time. So it was really, even though by 1974 we could have had private enforcement, and we did have private enforcement, okay? Let's not think that, it took until 2000. No, we did have many cases, including in Portugal. We had many cases before 2001, so it did happen a lot. But it was only by 2001 when Courage v. Crahan happened. It was a referral from the UK. And then this movement was very strengthened by the second case, Manfredi. These were the ones that really kickstarted the revolution. It's like in so many areas of the law where, you know, things existed before, but one moment becomes the crucial turning point where jurists start becoming aware of it and they start discussing it. It can be because there was a communication of the commission about it, or it can be because there is a particularly famous judgment, which was clearer, or which for some reason became more famous. And those were Courage v. Crahan and Manfredi. And we're going to see a little bit more what they said. But after these, you can see the dates there. After Courage v. Crahan, the commission started looking into private enforcement. And then there was first a study by economists, and then there was a green paper. There was another study ordered by the European Commission. Then there was a white paper. And finally, in 2013, we had the proposal for the damages directive. And this led to the adoption at the end of 2014 of the EU Damages Directive, Directive 2014-104. For those of you from outside the EU, a directive is a harmonization tool. It doesn't set the rules that are directly applicable, but it tells the member states, you need to create laws in your countries that respect these requirements and achieve these results. So it has to, they have to be transposed. But then they have, if certain requirements are met, they have vertical direct effect. Their provisions can have vertical direct effect. That means that they can be invoked against the state. However, they cannot be invoked against private persons who are not the state lato sensu, broadly speaking. Okay, they could be invoked, for example, against a public company controlled by the state, but they could not be invoked against a private person. The deadline, the directive entered into force in 25 December 2014, and that's an important date for succession of laws issues that we will discuss later. And the transposition deadline was the 27th of December 2016. Transposition in some countries was delayed. Portugal, for example, our law only came into force in August 2018. We don't really expect a lot of legal controversies surrounding that because of the issue of direct effect, that unless you're litigating against a public company or something, you won't be able to claim direct effect against a private company. So it's not very likely that we will be discussing the direct effect of the directive, which I forgot to mention for those of you unfamiliar with it. The direct effect only is created after the transposition deadline. Before that, there is no direct effect. And if you're curious about this, a little advertising there. If you're curious about this, there is a book coordinated by Professors Barry Roger, Francisco Marcos, and myself by Oxford University Press, and it discusses the transposition in the various member states in detail. Now, damages claims can be follow-on or standalone, or they can be mixed. They can be both. I would say that too much attention has been put on follow-on. And too much attention has been put at the EU institutions level and leading to the damages directive being really preoccupied with follow-on and neglecting things that are important for standalone. But also doctrine. Doctrine just keeps, because although there are a lot of empirical studies about the nature of cases, the types of cases that we've had in the member states, the matter of fact is that the vast majority of people, even high-level people, even at national competition authorities, legislators, etc., they work on the wrong assumption. They work on the assumption that the majority of cases are follow-on. That's just not true. So, for example, in Portugal, from 1988 to 2018, 93% of cases were standalone. 93%. Only 4% were follow-on and 3% were mixed. So this really shows that when we focus on follow-on, we're neglecting the vast, it's really just the tip of the iceberg, and we're neglecting the vast contribution to the enforcement of competition law that comes from other actions that are, most of them not even damages actions. And then you have the situation post-directive. Now, post-directive, its follow-on will clearly dominate in quantitative terms. Okay? There is no question about that. We know this from the trucks cartel already. In the trucks cartel, we've had, I'm going to talk about that a little more, but we have thousands of actions all over Europe. Now, that far exceeds, with one case alone, it's the same cartel, but with one case alone, you already have more, quantitatively more actions than you've had in the several years put together of all the member states. So quantitatively, yes, of course, follow-on damages actions will now dominate quantitatively. And that is also tied to the problem of something else that I will address later, which is the lack of mechanisms to group these actions. But this will not be the case if we think about the trucks cartel as one single case. So if you think about the trucks cartel as, you know, one cartel leading to many cases, but it's basically the same case being disputed, then you're going to see, and it's the same practice, which is important, only one practice being identified and pursued and enforced. The vast majority of practices will still, in my opinion, continue to be pursued and identified on a standalone basis, okay? But then there is also an important tendency for mixed claims. But before I get to that, I have a question here. Victor asks if the EU damages directive non-retroactive rule is a common practice in directives. So I don't have an idea if how common the non-retroactivity rule is, but it is the general rule of national law and EU law. Substantive rules are not retroactive. So it's not particularly surprising in that regard, the rule. What is surprising is the way that some national laws have approached it. But I will only get to that discussion later on. And this is really, you will be able to see, Victor, the impact of the succession of laws and retroactivity in some of the discussions that we're going to have in the third and fourth and fifth day. So I will get back to that at that time. Now, as I said, there is a tendency for mixed claims. Competition authorities will typically lie on what the Competition Appeal Tribunal described as low-lying evidential fruit. You know, they don't have to go after everything. It's really not that different for them if they declare an infringement with a slightly lower scope. They'll still be able to impose a very high fine and create a dissuasive effect. Their motivation is different from the motivation of private individuals who had damages and they want all their damages to be compensated. And so they need to identify the entire practice and for as long as it existed and as broadly as it existed. Competition authorities also have a tendency to settle. And when they settle, they also sometimes reduce the scope of the practice. Maybe they could have proven a bigger scope, but they decide not to because in exchange they get a settlement and they save a lot of human resources. And that's perfectly legitimate, understandable goal of management of public resources, but it's not nice for private enforcement. And then when people go to courts to seek damages, they will look at the practice, they will start investigating and say, but wait a minute, but this started before, or this is still going on. Or they will say, but this practice, they're talking about this practice only about this market, but it also happened on that one. Or it wasn't just for this group of clients, it was also, etc. So they will enlarge the scope in material terms, in temporal terms, sometimes even in subjective terms, including other infringers, for example. Another thing that often happens is that private enforcers will need to discuss that EU law is applicable when the National Competition Authority has only said that national law is applicable. And that will not be proven. The infringement of national law will be proven, and the infringement of EU law will not even have been alleged. So it's definitely not proven. And so it will be up to that. That is an interesting example where you can have the exact same scope of the practice, but the action is mixed because it is follow-on in what concerns the national infringement, and it is standalone in what concerns the EU infringement, even though it's the exact same practice. So the only thing you need to prove, really, is the effect on trade between member states. Somebody is asking, when I mentioned that 93% of cases are standalone, how many cases exactly are we talking about? This is based on a Portuguese study. So that was based on, as you see in the slide, in Portugal. So from 1988 to 2018, we identified 100 cases. And by the way, it's a misconception. Competition authorities are very vain. Sorry, they're not. But the competition authority has a tendency to assume that they're better than, they have a lot more resources and they're better than private enforcers. So they say, well, of course, we identify the infringements, and then people come along and they do damages actions, follow on to our decisions. But that's not always the case. There have been many examples of first you have private enforcement actions, and then the competition authorities act, right? So this is also interesting because in Portugal, for example, we have examples of you have a private enforcement action, the national court says no infringement, and then you have a public enforcement action afterwards, the same infringement, and the competition authority says yes infringement. It goes to the same court, and the same court says yes infringement. Different judges, but the same court. So very, very interesting dynamics that get created there, and interesting discussions for political scientists also about the way courts work and defer to authorities. So a little bit about numbers. So prior to 2017, 2018, before the transposition of the damages directive, we had studies in the early 2000s that pointed out that there was a drastic cultural difference between the EU and the US. In the US, the majority of enforcement was private, and the public authorities had a complementary role. In the EU, almost all enforcement was public. In fact, at the time, it was believed that almost all enforcement was public. And private enforcement was virtually non-existent. This is what they thought. We now know that they were focusing too much on damages claims, and they were having difficulty of access to data because there still hadn't been empirical studies done at the deep level at that time. And to be honest, it's very hard to identify, especially first instance judgments in many jurisdictions. So really, they were underestimating the amount of actions at national level. But one thing was they were absolutely right. There were very, very few actions for damages, and there were certainly almost no examples of successful actions for damages based on competition law. So there was a gigantic problem. I will give you the example of Portugal because I've done an exhaustive study about Portugal. When I did this study in 2016, experts in Portugal thought that there would be like 5 cases of private enforcement, and we identified 97. Ever since then, we've had many more. But just this is a good example. In Portugal, the trucks cartel has led just by itself to 70 cases. No, 80 cases by now. 80 cases on one cartel, where before going back to 1988, all we had was 97 cases that we could discover, because we know for sure that this number is seriously underreported, that there are many first instance cases that we never heard about and we will not be able to hear about. Competition law arguments in Portugal had a success rate of only 18%. There are several explanations for that, but I think the main explanation is that most of them were not very sophisticated and they were not well presented. They were put forward by generalist lawyers, sometimes with not much effort to go behind them. Somebody is asking is it in line with the principle of res judicata? I don't know what that question is about, Alexander. Maybe you can rephrase.
Yes. You were saying that there are cases in which, let's say, a court says in a private damage that there is no infringement, and then the competition authority and another court.
I see. No, thank you for your question. No, there is no infringement of res judicata because the the case is different. So in one, they're discussing the existence of an. I mean, I understand why you're asking that, because they're looking at fundamentally the same facts, and one says there is an infringement, the other says there isn't. But technically, there is no res judicata infringement, and they're definitely not bound by the decision of the private enforcement court when they're looking at it. I don't know any member state where that would be true, unless, of course, you're talking about a precedent set by a higher court in the UK or Ireland. But I don't know of any example where that happens in a common law jurisdiction. Now, someone else is asking, if firstly a private action is implemented, is the NTA public enforcement action in violation of the ne bis in idem principle? No, of course not, because it's completely different. One is a sanction that is aimed at dissuading this behavior in society as a whole and on the markets as a whole. And the other is an action intended to compensate someone for the damages that behavior caused. So there is absolutely no overlap between the goals of these actions. So there is no ne bis in idem infringement. And someone else asked why this case of private enforcement do not became public. I'm not sure which cases they're referring to, but basically, if you're referring to the underreporting, the idea here is that in Portugal, unfortunately, our first instance judgments are not public. They're technically public, and according to the law, but it's impossible. There's no database. It's impossible to search them. And in practice, very often they're not public. You try to get access, you ask a court for access, and very often you're refused, or there has to be a permission from a judge, and it's a strange situation. But basically, for researchers, there is no database where you can search them. Even decisions of higher courts, there is no complete database, because in Portugal, for reasons that escape me, judges can specifically ask for certain judgments not to be included in our database, and our database is not very friendly in terms of searching functions, etc. So it's just research challenges. There is a troubling tendency that we see, and I'm talking about Portugal. I think that we could probably extrapolate this to most member states, but of course this is just my imagination. I don't have empirical data to back this up. There is a troubling tendency for generalist courts to, when they're confronted with competition law arguments, private enforcement cases, there is a tendency for them to throw out cases, come up with procedural reasons, for example, to throw out cases, even if those procedural reasons infringe EU law. And we have an example of that in Portugal, in an Apple case, which was also litigated in France and went to a referral to the CJEU. I will mention that one later. Or they completely disregard the competition law arguments. They don't even respond to them. Or they respond to them, but they respond to them by applying civil law. I swear, this has happened. Somebody invokes competition law and the courts reply with civil law. Interestingly enough, first instance courts tend to have to be more prone to discussing and studying competition law than the Supreme Court. The Supreme Court has a very unfortunate track record in Portugal with competition law cases. It has repeatedly infringed the case law of the European Court on competition law. It is the first to apply civil law. It has done that in the past. Hopefully it wouldn't do that now. This is maybe years behind us now, but it applies civil law instead of applying competition law. Just as to give you an example, in 2014, in precisely one of those cases where private enforcement preceded public enforcement, the Supreme Court looked at a tiny little store that had a distribution agreement with a very big company that had made gas bottles for people to have gas in their homes. They said, well, competition law doesn't prohibit this because this little store is an agent, and therefore it's the same company as the big store. It's the same undertaking. So competition law doesn't prohibit this. And they also said competition law does not prohibit intra-brand restrictions. So two completely erroneous views of competition law, and no real remedy for the person who saw their rights infringed in this way, because unless they filed a tort action against the state for the Supreme Court decision, which didn't happen, it was going to be very difficult to solve this from then on. Okay, I have to move a little faster, unfortunately. Let me just check. Yeah, I have to move a little faster. So there, after the transposition, as I said, we've had a drastic spike in number of cases. The truck cartel alone has, we don't know, but at least 10,000 actions all over Europe. In Spain, there have been 5,000. It's enormous. Jurisdiction-wise, few countries have centralized, some countries have centralized jurisdiction, but others continue to allow generalist courts to discuss antitrust private enforcement. There's a bigger problem. For example, in Portugal, we gave jurisdiction for private enforcement to the competition court, but only when the action is based exclusively on competition law, because and that means that a lot of the cases are not going to go to the competition court. Many cases where you're going to discuss competition law and private enforcement, you're going to have to go to a generalist court, because usually you don't have just reasons of competition law. You might also have reasons of contract law. You might have general principles of civil law, good faith was also broken, et cetera, et cetera. You might have other laws like unfair commercial practices and things like that. So if you invoke one other cause of action, you do not have access to the exclusive jurisdiction of the competition court. You have to go to a generalist court. So that is still going to be a concern moving forward. The judges who have been allowed to specialize, it's been clear that there has been much greater sophistication in their analysis of private enforcement cases, which is why all over Europe, when we want to study precedents for certain solutions, we tend to look at the UK and at the Netherlands now. But don't get me wrong, generalist judges, we have had generalist judges set wonderfully positive examples, which is commendable given their workload and the effort that they have to put into studying a completely new area of the law usually for them. And some people really took the time to study issues and come up with amazing decisions. But as in everything, there are great examples and then there are bad examples. A few other ideas about what has been changing now with the damages directive. Assignment model. There are many things. I tried to choose a few things to point out to you, but of course there are many other topics we could discuss. Assignment models. Assignment models is basically when somebody sells, to simplify it, sells their rights to claim compensation to someone else. That person bundles them and files an action in their own name, but with everybody's credits. And this was pioneered in the EU by a company, Cartel Damages Claims, but ever since then, it has been used by many people, backed up by litigation funders. And they're now extensively used, and they're being accepted, except in Germany. Germany is being very formalistic and creating problems for assignment models. And there are appeals pending in regards to that. Now, litigation funding. I personally believe the success of private enforcement is dependent on countries allowing litigation funding solutions and allowing them in ways that will make them economically viable. Because, of course, if it's a private company discussing with a funder, they're free to do so as they wish. But national laws in some cases might still impose restrictions. A bigger concern is litigation funding for consumer actions, where national laws will definitely impose restrictions. This is being discussed now. It was already discussed in Merrick's v. MasterCard in the UK. And I think that was a perfect example of what happens when you have a court that has a very good understanding of economics and a very reasonable approach to the effectiveness of the law. And they came up with a model. They approved the litigation funding model with a few tweaks that really makes it possible for consumer actions to be funded by litigation funders, and it's commendable what they did there. Although then they did something else that completely destroyed the possibility of consumer redress, because it made it virtually impossible for mass damages claims to be brought to protect consumers, and that is now pending an appeal at the British Supreme Court. The appeal court has already reversed the Katz decision. We don't know what the Supreme Court will say. Hopefully by the end of this month, we will have that decision. Then for mass litigation and collective redress, this is really something largely determined by national procedural rules, although as you will find out later, EU law might have something to say about this. it's a problem, because Spain is the perfect example of this. If you have 5,000 cases being litigated in many courts all over your country with the same dispute, that is an obvious problem. It's an obvious problem because obviously you're going to have different decisions. Some people are going to decide issues of law differently, not to mention that they're going to assess matters of fact differently, but issues of law are going to be decided differently, which is a big no-no, because EU law has to be uniformly applied. So this is a serious concern. And there are some solutions for mass litigation. So for example, in the trucks cartel, you've seen that you can have situations as in Spain, which by the way, is created basically because of Spanish procedural rules on costs. It's much more economically advantageous for lawyers to file cases separately in Spain, because they get compensated, they get higher costs at the end in lawyer fees paid by the other side if they do it that way. So there is really, the economic incentive is all on the side of splitting up the actions into many, 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 many small cases. And then you have examples of how the trucks cartel has been litigated by joining thousands and thousands of claims and going to one court in Germany, one court in the Netherlands. So it really depends on each country. One topic that really concerns me is consumer protection. And I want to point this out to everybody because I think it's the most shocking aspect of private enforcement in the EU. To this day, we have never had a truly successful damages actions leading to compensation for consumers in the antitrust area. Not one. The only thing that came remotely close was an action in the UK that was, the result was laughable. This was before the UK had an opt-out system, so they still had opt-in, meaning they couldn't, they only represented people who opted into the action. And what happened there was that they reached a settlement. It was a football jerseys shirts case. And the settlement said that anybody who came forward to ask compensation and show that they owned the football jersey shirt, I think I'm simplifying, but they would get a certain compensation. And they estimated, if memory does not fail me, that over 2 million people had been injured. And I think basically only a few thousand, very few thousand came forward to ask for their compensation. So it was a failure. And the company managed to keep the vast majority of the profit that it had made with that infringement. There is, this issue needs to be addressed. The directive does not address it, has no provisions on collective redress. Thank goodness, because at the time, the European Union institutions had been convinced by lobbying that they should only allow opt-in solutions and not allow opt-out. There is extreme lobbying pressure being done by companies and law firms, including by the American Chamber of Commerce, to get the EU to say only opt-in, only opt-in. Why? Because in the USA they have opt-out and they know what that means. They know that opt-out works. They know that opt-out leads to actual millions having to be paid out to consumers. And they have created the boogeyman of the abuse of opt-out. And I don't have time to discuss this, but I'll just say this. It's very easy to scare people about, oh, if you allow this, it'll be abused, and to forget that right now, we don't even have it's not working at all. So let's first see if we can come up with a system that might work, and then if it is abused, we'll worry about that then. Incidentally, every opt-out country has massive restrictions on abuse, and it's usually based on control by the courts. The court controls the proportionality of the settlement, the proportionality of payments to the lawyers, et cetera, et cetera. So there are ways, less restrictive measures, more proportional ways to allow opt-out, and which is absolutely necessary to get consumer compensation to actually happen. But of course, I have to express here an interest, which is that I'm also a practicing lawyer, and I have a case pending to defend consumers. And so please take everything that I'm saying from the perspective that I am an academic, but I'm also a lawyer, and I'm trying to get compensation for consumers. So, you know, in accordance with ASCOLA transparency principles, I have to point that out. Now, another discussion concerns forum shopping. A lot of some countries have looked at competition law as an opportunity. They said, well, you know, here's a market. Let's get companies from all over Europe to come litigate their cases here. And other countries just don't think in those terms. They want less work for their courts, not more. It's great for lawyers. If your jurisdiction is attractive, that is amazing for lawyers because they get a lot of work that is not just from their country, but from other countries. The UK has been so far perceived as the best jurisdiction to litigate antitrust. It's certainly very sophisticated, has great precedents. I think it's going to lose that role now, especially for the European Union, because with Brexit, unless something happens that will be surprising, their decisions will not be binding in the EU, and their judgments will not be binding in the EU. So unless they include that in the negotiations, they will probably be less attractive in this sense for private enforcement litigation. And one country has taken advantage of this. The Netherlands has completely taken the lead. They are now by far the friendliest jurisdiction for antitrust private enforcement. They have great judges that know what they're talking about. They have a very economic friendly approach, very sophisticated. Sometimes you can even litigate in English for the New Amsterdam, I think it's called the Amsterdam Commercial Court. But of course, the other side has to agree to that. And they're relatively speedy. Two main problems with the Netherlands, language barrier, also legal differences, because if you're coming from another country, you don't know any, there are a lot of differences that you will need to be clarified on. But mostly the language barrier and the high costs of litigation in the Netherlands, especially with legal fees, which compared, if you're coming from Southern European countries or from Eastern European countries, the legal fees in the Netherlands will be very, very high. So it might be prohibitive to litigate in that country, unless you're bundling action. Germany was also perceived as an attractive jurisdiction, but it's proving not to be because it's being so formalistic. And it's coming up, well, I mean, it's a great country for the infringers, but not a good country for people who are trying to actually get compensation, except unless in the most classic of actions of one company against another company, then it might be fine. But in any attempt to come up with collective redress or mass damages claims, it's been incredibly formalistic. But other countries have good track records, and we'll see how it evolves. France has great decisions. Sweden has a lot of precedents already, and some countries used to attract attention for the wrong reasons, like Italy with the Italian torpedo, and they are also changing. So we'll see. To think about the future, I think that the main problems here is that competition law is being applied manifestly heterogeneously throughout the EU. Completely different solutions are being arrived at, not just from country to country, but within each country, from judge to judge, sometimes in the same court, sitting in offices next to each other. And they're arriving at completely different interpretations of EU law. In the trucks cartel, for example, there have been completely divergent positions about whether a subsidiary can be held liable for the behavior of its parent company. One court referred the issue to the ECJ, and some Spanish courts didn't even decide to wait. They know that the referral was pending, and they said, whatever, I'll just decide it anyway. And of course, some decided in one sense, some decided in another. And this is obviously the main concern right now from an EU law perspective. And there is a manifest need for a European version of what in the America is called MDL rules, multi-district litigation rules, meaning a way of, if actions have been filed in many, many courts, in many states, a way of bundling them together in one court to lighten the load of the judiciary, but also to avoid heterogeneous decisions. Of course, this is easier in the US than it is in the EU because of the way our judicial systems are set up and the different way we function. One possible solution, and here I'm dreaming as an academic, allow me to do so. One possible solution is to give jurisdiction to the general court to discuss damages actions, private enforcement actions of competition law, or even to create a new specialized court. It could even be regional courts, EU courts, federal courts that would be empowered mainly for damages actions. Why not? It certainly seems like something that would be of interest even to the judiciary systems of each member state, because right now the situation has already become untenable and will certainly become worse so as we have more and more follow-on cases. By the way, there's a lot of discussions about, companies might get a reduction in fines if they offer to compensate the victims. I've never heard of this. No company has ever said in antitrust. I infringed the law, and I will voluntarily compensate injured parties. It hasn't happened, but it would be interesting. It would be interesting if competition authorities somehow fostered this behavior by, for example, offering significant reductions, very significant reductions of fines. I always find it amazing that our states prioritize fines over compensation, because what's more important to the state? That people, that their consumers and their companies are compensated, or that somebody pays a fine that goes into the state budget but doesn't contribute to the injured persons at all? Protecting injured people should be the priority. So why shouldn't we turn public enforcement to compensation? Why don't we have a publicization of the redress, especially for consumers and small and medium companies? And some sectoral regulators in some member states are already doing this. Instead of applying fines, they order the companies to compensate consumers. But that creates constitutional problems in some countries. And well, it's just a very long discussion. And certainly there has been no openness from competition authorities so far to this idea that I am aware of. Okay, I'm a little behind schedule, but if there are questions concerning this part, I'm actually quite a little bit behind schedule. Has there been forum shopping by companies, or the EU rules that protect consumers from abusive consolidation also protect companies harmed by the cartel? I'm not entirely sure I understand the question. So there has definitely been forum shopping, both by infringers, but especially by people who are trying to get compensated. And there's lots of interesting things, if you want to study that, about the very broad interpretation of the anchor defendant in the UK. So that's really interesting. And then you say the EU rules that protect consumers from abusive consolidation. I don't understand that question. I'm sorry, Filippo. Do you want to explain the question? Okay. So let's move on to what is the case law that we already have about private enforcement. Now, in the next slides, you will see that I have included links. You obviously cannot use them, I think, now because on the screen, but when you do receive the PowerPoint, you will have the links to these cases. Now, before I show you all that text, most people drastically underestimate the number of cases associated to private enforcement of competition law. They think that there have been like 6 or 7. That is not true. There have been 38 cases on private enforcement of competition law in the EU. It's, of course, some of these cases arise from private enforcement of competition law, but do not necessarily lead to discussions relevant to the private enforcement of competition law. And this list is a list that I've compiled, but it's probably incomplete. There are 6 pending cases, and we will be going over them, all of these, very succinctly, of course, in the next slides. So we have 17, what type of cases? 17 are referrals. Referrals, remember, is when a national court has doubts about EU law and it asks the ECJ for clarifications. So we have 17 referrals from actions that relate to 101 or 102 because it's damages or validity of contracts or injunctions. We have examples of all of those. 2 of referrals on access to evidence of people who were trying to prepare a private enforcement action to understand if they had a right to compensation. 5 cases by potential claimants who were fighting a refusal of access to commission files. Now, this is a direct action before the General Court of the European Union. It's not an action at the national level. So basically, they want to have access, and the Commission says no. It's a lot easier to get access to Commission documents if the national court asks them than if you directly ask them to the European Commission. And then there are 9 cases by infringers meant to prevent the publication of Commission decisions or disclosure of information. Obviously, because as I told you, the great concern now is what information shows up on the decision. And so infringers are doing their best to make sure that as little information as possible is divulged so that you do not facilitate private enforcement. And you have had a significant growth in the litigation either to completely prevent the publication of a decision or the disclosure of information. Now, you might think, well, why are they doing that? They're always losing these cases. Why do they keep filing them? there's a very obvious reason. As long as they file them, they suspend the publication, they postpone things. Even if they win 4 or 5 years like this, that's huge, because if people do not have access to the evidence that they need, and they have to wait 4 or 5 years before filing their claims, first, they're going to have problems in discussions of limitation period by the time that they file their claims. And second, they're also going to have trouble getting evidence, because 5 years have gone by, a lot of evidence has disappeared. So gaining time is unfortunately a very wise strategy if you're trying to fend off private enforcement. One case where a third party seeks annulment of a commitment decision because the commitment decision has in fact impacted private litigation that they have ongoing. And for referrals connecting to state aid. We clearly see a boom in the number of referrals now, and I think this is interesting because when the General Court was created, the CJU, so DCJ, kind of took a back seat to the definition of competition policy and would only intervene really when it seriously disagreed with the General Court on something. But most of the issues were being clarified directly by the General Court. Whereas now you're going to have the CJU once again becoming a competition law court, because you're going to have a lot of not just procedural but substantive questions coming from private enforcement cases in the national courts. It will be interesting to see if the ECJ will decide to use the ability that the treaty gives it. If the European Union will use the possibility that the treaty gives it to allow the General Court to answer referrals in some areas, for example, in competition law. So the ECJ could get tired of this after a while and say, let the General Court reply when it's competition. Then, what are the cases? So I've grouped some of them because it just didn't seem, we didn't have time. So I'm only going to talk individually about the ones that seem the most important. If you're interested in access to evidence, you absolutely need to take a look at these. These are the challenges to the Commission refusals to provide access. Okay, you're going to have access to these presentations, and then you have the attempts by the infringers to prevent dissemination of information by the Commission, and then you have the state aid cases. I identified these ones, but I think there are many more. Look how one of the fundamental building blocks of EU case law, Costa contra Enel, was also a state aid case. It was a state aid private enforcement case. That was not the only grounds that they had, but they also invoked state aid. So one of the first contributions to direct effect and primacy of EU law was because of a state aid, this private enforcement disputes. And then, okay, Article 101 and 102 cases. So it all starts with BRT Sabam back in '74, where they declared the direct effect of those articles, meaning that you can go to court and invoke those provisions against other private parties or public. Then in the Limites in 1991, we clarified that national courts, well, they didn't really clarify, but this is an important judgment if you're looking at the issue of whether national courts can make negative declarations of infringements of 101. Then you had Banks. Banks was a very interesting case, a coal and steel treaty case. And it's important today, not so much because of the judgment, but because of the amazing opinion by Advocate General Van Gerven, who was just decades ahead of his time. And the Advocate Generals in the last 5 years have gone back to this opinion to inspire themselves to write their opinions, which have led to the big steps now in the case law. Well, I mean, the court has taken those steps, but the Advocate Generals proposed those steps. And you find all the core ideas you already find in this opinion of Advocate General Van Gerven back in '94, so, or '93, I think. Then you have Master Foods. Master Foods is a really important decision, a really important case that says that this Commission decisions declaring infringements are binding on national courts. Subsequently, this was codified in Regulation 1/2003, but we will discuss this further. There are important reasons not to forget about Master Foods. It continues to apply, and you can't just rely on the rule of the regulation. So this means that when a commission has already adopted a decision saying that there is an infringement, you don't discuss that at the national court. It's proven, irrefutable presumption. And that's also, by the way, what the regulation says, and that's also what the directive has now said for national competition authority decisions, extending this to national competition authority decisions when they have been taken in the same member state. A bigger discussion there. So then you have Courage v. Crahan. And please, these are very succinct summaries. There's a lot of interesting points in a lot of the cases that I'm going to talk about now. I don't have time to discuss them, but I chose some highlights. So in Courage v. Crahan, you say that the court tells us that Article 101, and of course also 102, directly grants rights to damages to injured parties. So the right to damages comes from Article 101. It was already clear from, well, we could already guess that from 73, but it hadn't specifically been said. And therefore, national courts are obliged to safeguard these subjective rights deriving from the illegal order. And matters governed by national law are subject to the limits of equivalence and effectiveness. Equivalence means you cannot treat rights coming from the illegal order worse than you treat rights coming from your country, national legal order. Effectiveness in the context of effectiveness means you have to respect the effet utile, the effectiveness of EU law provisions, but it is usually expressed as you cannot render the exercise of the right to damages, or of any right, in fact, deriving from the EU legal order, impossible or excessively difficult. That is the principle of effectiveness. And the principle of effectiveness, if anybody who knows the history of case law, of EU case law, it is fundamental, and it has been used so often for so many fundamental steps that have been taken. It is really, together with primacy and with the principle of loyal cooperation or sincere cooperation, it's really the tools that allows the case law to develop EU law and to extend it beyond, many times beyond the dreams of the member states who adopted the treaty and who adopt legislation. Then you had Manfredi. Manfredi essentially came to clarify courage and give us some further depth. There are a lot of things in Manfredi that are interesting. You know, for example, that the court further specifies what is the right to damages. It says that it must include damnum emergens and the lucrum cessans. So it talks about limitation periods. It gives us a lot of interesting information already about limitation periods and what EU law requires in that regard. I'm not going to go into the details of a lot of this because in the next chapters, we will be looking at a lot of these questions. So we'll be going back to these cases to discuss them. Bevlijdigheid was about access to documents. Somebody wanted access to a case file of a national competition authority, and this was including to leniency documents. And basically the court said, yeah, you do have a right of access, even to leniency documents, but you need to weigh proportionality. And that was further clarified in Donau Kemie, where the courts continued that idea and made it very clear that you cannot have an absolute prohibition of access. You need to, even for leniency statements, the court said, you need to have the possibility of a case-by-case assessment, which is fascinating because 1 year later, the damages directive comes out and then produces an absolute prohibition of access to leniency statements and settlement proposals, which there is for people doing PhDs and things, that's a really interesting discussion whether or not the damages directive is incompatible with EU law, with primary EU law, because Bevlijdigheid and Donau Kemie interpreted the treaty and general principles. So secondary EU law also has to respect that. An interesting theoretical discussion. I don't think in practice it has significant impact whatsoever, but theoretically it's interesting. Then you had Otis. Otis was a funny case because it comes from a Belgian dispute where the European Commission, first it had identified the lifts cartel, the escalator and lifts cartel, and then it went to Belgian court asking compensation for the European Union institutions for the cartel that it had identified. And that led to a few discussions about human rights and, they even questioned the right of the European Court of Justice to interpret this because it was acting in its own interest. It was a European Union institution. Also some very interesting theoretical discussions there, but fundamentally what we take today from that case are these clarifications, some discussions about fundamental rights, and also the idea that the Commission can file claims for damages before national courts on behalf of the EU, of course, even if it's in the context of follow-on cases to its decision. Then we had CON, another one associated to, if I'm not mistaken, to the escalator and umbrella, to the escalator and lifts market. And there, the great novelty was that under EU law, you are entitled to damages also for what is called, to be compensated, also for what are called umbrella damages. Umbrella damage is when you have a cartel, like there are 5 companies on the market, 4 companies do a cartel. The 5th company is not a participant, but it has a very small market share. Economists tell us that in principle, the other ones which occupy almost all of the market share will mean that the overall price on the market will be increased. And so that the product sold by the company that did not participate in the cartel will be sold at a higher price. And that is a direct result of the cartel. And so the court said, well, in that case, under EU law, you have a right to sue the cartel members for the damages, even if you purchased products from the company that did not participate in the cartel because of the umbrella effects. Another interesting implication that was only really fleshed out later is that the court was therefore saying that the causality test was determined by EU law. Then you have Gasorba. Gasorba discussed the binding effects of EC commitment decisions and of the statement of objections that precedes it. We will have a chapter talking about this, so talking about binding effects, so I will not look into it now, but just to tell you that most people used to think commitment decisions doesn't have any effect on private enforcement, is completely irrelevant. At most, it gives you some information, and now we know that that is not the case. In fact, there are very significant effects from proceedings leading to commitment decisions. Then we have Group Canal Plus, which is still being appealed, but it's also about a commitment decision. This is the one which has been filed as a direct challenge, so not as a private enforcement action before the court, but as a direct challenge to the Commission decision by a third party. And if I'm not mistaken, the Advocate General opinion already came out, and the suggestion was that so the General Court upheld the Commission decision, but if I'm not mistaken, but the Advocate General, I believe, has suggested that it should be annulled because the interests of third parties were not duly considered. So again, a lot of things are happening with commitment decisions that weren't foreseeable some years ago in its interplay with private enforcement. And then you had Skanska. Now, Skanska was a bomb. Skanska is really the turning point. If Courage v. Crahan started the private enforcement revolution, Skanska turned it on its head and made it an EU law issue. I mean, it already was a EU law issue, but we just didn't understand exactly to what extent. And of course, some people, and I include myself in that group, were saying that before Skanska, were already saying that this was the necessary solution, but the vast majority of people did not believe so. So there is a problem in competition law called the sausage gap. It's called the sausage gap because of the sausage cartel in Germany. Basically, at the EU level, you ascribe liability to the undertaking. That's the economic unit, right? And you impose fines on any legal person within the economic unit. Well, this is a little debatable, but it was certainly clear from the case law that you could impose a fine on the parent company for a behavior of the subsidiary if the parent company controls it or could control it. And you could also, it was also clear that you could also impose on the same fine on the economic successor. This is fundamental because if you don't have these two possibilities, it's too easy to escape responsibility. You just do corporate restructuring before the fine is imposed, and you can even continue active on the market, but the legal person doesn't exist, and therefore you get away. You don't impose the fine. Now, at EU level, that was not possible because of the case law, but at national level, in many countries, it was. In Germany, it was. In Portugal, it has been, etc., etc. It's debatable whether that is compatible with EU law, but the national courts haven't had that discussion yet, or they have decided against it. And so the sausage gap was precisely a situation where a company got away, several companies got away with paying cartel fines through corporate restructuring because you couldn't ascribe liability to the economic unit under German law. That is a problem in public enforcement, but it's also a problem in private enforcement in the exact same terms. And that came up in Skanska from our friends in Scandinavia. They sent us this amazing case where there was the risk that somebody was going to escape civil liability because of a succession, an economic succession. And the court said several amazing things. It said, first of all, it really clarified that the liability for infringement of EU antitrust law, that is determined by EU law. And we'll get back to this, so I don't want to get into this detail, but this is fundamental. Liability is determined by EU law, which means it's not up to national law to decide if the parent company or the successor is liable. That's an EU law issue. And everything, the court added that everything that this court has said about the concept of undertaking, the single economic unit, the economic successor, everything that the court has said about that in the context of public enforcement will also apply to private enforcement, to liability between private enforcement. The solution has to be homogeneous, which is great because, of course, this case was about economic succession, but because of this answer, we know that there are many other things in the case law that we can now apply also to private enforcement, even though they were clarified for public enforcement. Then you had Cogeco, and here I have to be very careful because I am a lawyer. I represent the plaintiff in Cogeco, and the case is still being litigated before the national court. I will just say that right now I will just say that it discusses many things. I would highlight the temporal scope of application of Directives 2014/104, and the implications of the principle of effectiveness for national limitation periods prior to the damages directive. Also after the damages directive, of course, because the principle continues to apply, but it was discussing it in the context of prior to the damages directive. And this one is a particularly important discussion that has a wide-ranging impact all over Europe. And depending on how you interpret the case, the consequences of Cogeco might be that thousands of actions in the coming decade will have been saved from time barring. We'll get back to that when we discuss limitation period. And then you had Otis. Otis was also about the causality test, again, elevators. Here, very interesting case showing that, we usually think about a relatively close causal link, and the court is imposing a very low threshold for a causal link. The court is saying public authorities who, because of national law, they were forced to give out loans to companies, and the companies were affected by this cartel. They paid more for the lifts. If they paid more for the lifts, they had to, I'm simplifying a little bit, but they paid more for the lifts, so they had to ask for greater loans, therefore the public authorities have to give greater loans, and they had to give greater loans with low interest, and therefore they were entitled to damages under EU law. There was a sufficient causal link, and for all Germanophiles out there, and Portuguese civil law is also German-based, German-inspired. This implied excluding German way of thinking about the scope of protection of the norm, for example. The court either excluded that way of thinking completely, or it said, well, this is within the scope of the protection of the norm, interpret it as we will, but the end result is that in this situation, these people should be entitled to, these public authorities should be entitled to damages. And then we have several cases on jurisdiction and on the Brussels I regulation. Two of these relate to jurisdictional clauses, and that is a really important discussion, which can be extended also to arbitration clauses. That's the CDC case and the Apple case. And basically, this case always a little hesitant, but we have already a lot of clarifications. If courts have questions about whether or not they have jurisdiction, they have already a lot of answers in these cases, specifically for competition private enforcement. And then you have the pending cases. What questions are already pending before the court that we will know the answer to soon? They're in a chronological order. So again, Brussels I regulation. If an antitrust dispute arises in the context of a contract, should or can jurisdiction be determined on the basis of the rules for torts? I mean, this seems like a pretty straightforward question to me, but it was asked. The Group Canal Plus appeal is also pending about the commitment decisions. We have the Repsol case. Spain has had hundreds of cases with gasoline stations and litigations with this for years now, and this is just a continuation of that. But this is a really important referral because it talks about the binding effects of NCA decisions before the damages directive. Does EU law, through the principle of effectiveness, probably, does it require some kind of binding effect for NCA decisions, like the directive now requires? So did it already require before the directive? So interesting. And there's also an issue about what if the decision refers to a network of agreements? Does that binding effect apply to all agreements in that network? You have the Dutch air cargo case, geographical temporal scope of application of EU competition law and potential extraterritoriality. Very specific question, but I'm not sure if this one is going, depends on how, maybe the court will give us broader clarifications, but the facts are really specific. And then you have two cases arising from the trucks cartel dispute, both of them from Spain. One coming from Barcelona, which is a continuation of Skanska. Can subsidiaries be liable for parent company infringements? This has not been clarified really. I mean, yeah, we have some hints, but not particularly clarified even at the level of public enforcement. So very interesting question there. And then Volvo, this is a dispute. I mean, I personally thought that this had already been solved, but it's creating a lot of problems in Spain because, as I told you, the trucks cartel is being litigated in many, many, many courts all over Spain. And this question keeps coming up. Does the Brussels regulation tell us that Spanish courts are competent? When it says, so the rule is the courts of the country where the court competent is the one of the place where the damage occurred. And the question is, does that mean the court of the place where the damage occurred? So if the injured company is from Barcelona, the damage was in Barcelona and the Barcelona court is competent? Or does it mean the courts of the member state where the damage occurred, in which case all we know from the Brussels regulation is that Spain is competent, and then it's up to Spanish rules to determine which court is competent. I'm not going to get into this now. There are also two famous, well, not famous, but important cases of the EFTA court that have to do with private enforcement of competition law, and that preceded. But you cannot apply them entirely. Be careful, because EFTA law is different from EU law in some regards that are important. And there you go. I really didn't expect to take the 2 hours, so I apologize. But we still have a couple of minutes for questions. So if anybody has any issue now to raise, please do so. No? You could just say hello and start speaking if you want.
Hi, this is Diana. I'm joining from Warsaw, Poland.
Hi, Diana.
Thank you for this course. It's very useful. And I apologize. I had joined like 5 minutes late than scheduled, so I missed the beginning of your speech and first like 2-3 pages of your presentation, and I just wanted to or any other like introduction message that I missed.
I'm so sorry, Diana, you broke up at the crucial part.
Really?
Yes, what are
maybe it's my internet. Maybe I will type the question.
Okay. In any case, I will, so as long as I have people's emails, and I only have, so far, I only have the emails of the University of Lisbon law students, but you could always send me a message, an email with your email, so I add it to the list, and I will be providing these slides, so you can have, you can see what you missed. Okay, so far nobody else has said on the chat that they wanted to ask further questions. Well, I will, Diana. I don't really know what I said in the first 5 minutes, but I think
Okay.
I didn't get past the preliminary. I wasn't yet within the first chapter, so you can just look that up in the slides. Then, Joe has a question. Yeah.
I'll just talk about it if that's all right instead of typing. I can't type that fast.
Yeah.
There was figures for the awards awarded by courts were much less than what you could get in arbitration. So what are the benefits of actually going through the courts rather than arbitration? What can you get from that?
Okay, first of all, those figures are only for Portugal, and
Right.
so you shouldn't extrapolate to all other countries. And the other thing is that this has changed. So it's not the reality of private enforcement now, especially in countries with specialized competition courts, will be very different. And the damages that we are seeing, for example, already in the trucks cartel, have not, even in countries that didn't have a lot of experience with private enforcement, they're not fitting into that old pattern. So I think that you can't really compare history to the present. But still, there is a temptation to go for arbitration. The thing is that it's really only useful between large companies.
Right.
It's not going to be a viable option for consumers or for small and medium undertakings.
All right, cool. Cheers.
I think, I don't know, maybe we'll be surprised in the future. The US has surprised us. Companies were blocking consumers' access to redress with individual arbitration clauses. And some very smart lawyers came up with a system where they did mass arbitration, just filed thousands and thousands of arbitration claims. And the companies refused to pay the arbitration fees because in themselves there would be millions and millions and millions, and the court forced them to. So sometimes, you know, these things take interesting turns. Okay, this is the absolute limit of the time that I could take up. So thank you everybody for being present, and we will continue this tomorrow at the same time. Thank you, everyone.
Thank you.
Thank you.
Thank you.
Thank you, Miguel.
Thank you.
Thank you.
Thank you very much.